We are live, sir.
Welcome to all those who tuned into Anekdhara's webinar on political funding, problems with electoral bonds, and way forward. In recent times,
We are live, sir.
In recent times, issue of electoral bonds have dominated the discussion into Anekdhara's webinar on political funding, problems with electoral bonds, and way forward.
Sir, somebody is
We are
live, sir. Watching YouTube, sir. Somebody is watching YouTube.
In recent times, issue of electoral bonds. Sorry for the interruption. In recent times, issue of electoral bonds have dominated the discussion in various fora, especially media which is not considered mainstream. Mainstream is supposed to have not highlighted the issue to the extent it deserved. That apart, electoral bonds are themselves part of the basic issue of how political parties fund themselves, both in electoral and non-electoral battles. Political funding in India faces several challenges and issues, and a few of them in brief are opacity and lack of transparency, role of black money, foreign funding, unequal playing field, and regulatory gaps and loopholes. To address these issues and many other related issues, we are fortunate to have a person no less than Professor Jagdeep Chokar, the man in the forefront in the fight for electoral reforms and also against electoral bonds through the organization co-founded by him, namely Association for Democratic Reforms. The session will be moderated by Professor Nishim Mannathukaran. I will introduce Professor Nishim Mannathukaran, who will conduct the further proceedings. Professor Nishim Mannathukaran is Professor, Department of International Studies, Dalhousie University, Canada. His main research interests are focused on nationalism, post-truth, development and democracy, modernity, Marxism, post-colonial theory, and the politics of popular culture. Professor Mannathukaran is the author of 2 books. He is columnist in the Indian press, and he has authored over 120 articles which have appeared in the Hindu, the Wire, the Telegraph, the Indian Express, Outlook, Scroll, the Quint, Deccan Chronicle, Asian Age, etc. And in Malayalam in Mathrubhumi and Samakalika Malayalam and Kalai Kaumudi. Professor Mannathukaran's writings have been translated into Marathi, Tamil, Kannada, Hindi, Portuguese, German, and French. We at Anekdhara are also fortunate to have him in the advisory team. He plays a key role in identifying the topics and the speakers. Thank you, sir, and for accepting to be the moderator. And over to you, Professor Nishim Mannathukaran.
Thank you, Mr. Ravi Babu. It's a pleasure to be here. In a landmark judgment on February 15, the Supreme Court struck down as unconstitutional and manifestly arbitrary the electoral bond scheme, which provided blanket anonymity to political donors, as well as legal amendments which allowed rich corporations to make unlimited political donations. As Chief Justice Chandrachud noted, would we remain a democracy if the elected do not heed the hue and cry of the needy? We ask ourselves whether the elected would truly be responsive to the electorate if companies which bring them huge finances and engage in quid pro quo arrangements with parties are permitted to contribute unlimited amounts, the judgment noted. Pointing to the inequality between the rich and the ordinary citizen fostered by the scheme, the judgment observed, this is violative of the principle of free and fair elections and political equality captured in the value of one person, one vote. Besides, the anonymity clause, according to the judgment, violated voters' fundamental right to information about political funding enshrined in Article 19(1)(a). Since the judgment, various sections of the nation have been engaged in a debate on the nature of political financing and election funding, which one can say lies at the heart of the robustness of a democracy. The Association for Democratic Reforms was the lead petitioner in the challenge to the electoral bond scheme. It went to court in 2017 when the scheme was first introduced. Professor Jagdeep Chokar is one of the 3 founder members of the Association for Democratic Reforms. Jagdeep Chokar was a professor of management and organizational behavior at the Indian Institute of Management, Ahmedabad, from 1985 till 2006, when he retired. He also played the roles of a dean as well as the director. He has taught in several countries, including Australia, France, Japan, and the United States. His research has appeared in several international journals. He has also contributed chapters to edited books and has written several teaching cases. He is the lead editor of a volume titled Culture and Leadership Across the World, the Globe Book of In-Depth Studies of 25 Societies, brought out by the Global Leadership and Organizational Behavior Effectiveness Research Program, and published by Routledge. Professor Chokar is also a bird watcher and conservationist and a trained lawyer. Before becoming a professor, he was an engineer with the Indian Railways and worked as an international marketing manager for 4 years. For over 20 years now, Professor Chokar has been a citizen activist for improving democracy and governance in the country. As a member of the Association for Democratic Reforms, he has been working on electoral and political reforms. His writings on these topics, as many of you would have noted, have appeared in the popular press. He is also the founding chairperson of Ajivika Bureau, a civil society organization that works on issues pertaining to internal migration in India. It is a pleasure to have you here today, Professor. Over to you.
Thank you, Professor Naseem Mantakuran, for a very, very generous introduction. I would begin with a minor correction that we are not only 3 founders of the Association for Democratic Reforms, there were 11 founders, 8 of whom were professors in the IIM at Ahmedabad, 2 were the alumni of that institute, and 1 was a professor in the National Institute of Design in Ahmedabad. So this is just for record, but you were right, just the 3 of us are now active in the process. Others are kind of dormant or they have moved on to other activities. So that's, with that correction, let me thank this organization for inviting me. And it's a privilege to be addressing such a distinguished audience. Coming to the topic of the day, electoral bonds. The expression electoral bonds first appeared in the Indian lexicon, if I may say so, on the 1st of February 2017. That was the day when the then finance minister, Mr. Arun Jaitley, who's no more with us tragically, he made a budget speech in the parliament. And in the budget speech, there were 2 paragraphs which were titled Transparency in Electoral Funding. Now, the title itself was very encouraging. And in the first paragraph, he described how for the last 70 years, we have been trying to bring about transparency in electoral funding, but nothing seems to have succeeded. And in the second paragraph, he introduced the concept of electoral bond. And he briefly described what this scheme would be, and he said the details will follow. Now, people listening to the budget speech were very pleased that there will be some action to bring transparency in the electoral funding. But then the very same afternoon, the finance minister apparently holds what is called a customary media interaction. And in a report of that customary media interaction that I read in the Indian Express on the 2nd of February, the finance minister was reported to have said that the bonds will be in the form of bearer bonds. The identity of the donor will be anonymous. Now, it was from reading that sentence or these 2 sentences that some alarm bells were sounded in the minds of some people, I being one of them. And I wrote the very next day a piece in a digital media outlet where I said that I am looking for a dictionary which will tell me that transparency and anonymity are synonymous. They mean the same thing. Because to my uninitiated mind, transparency and anonymity were antitheses of each other. If there something was transparent, there could be nothing anonymous in it. And if something was anonymous, then there was no transparency. So that was the beginning of the doubt about the scheme. And as more and more details of the scheme trickled out, it was quite clear that the scheme had significant problems. And therefore, in September 2017, Association for Democratic Reforms, ADR, the organization I work with, they filed a public interest petition in the Supreme Court of India requesting that the scheme be declared unconstitutional. Now, it is important to note that the petition was filed even before the scheme was notified, which was done in January 2018. So the questions about the constitutionality of the scheme arose right in the beginning. One of the primary reasons for that, and which has not yet been adjudicated, is the scheme was passed as a part of a money bill. The budget is a money bill because it deals with the government funds in the Consolidated Fund of India. And I think Section 100 or 101 of the Constitution described the money bill as something which has to do with the money collected by the government and spent by the government. Now, these two paragraphs were included in the budget, and therefore we felt the advantage or the specific characteristic of a money bill is that it does not have to be passed in the Rajya Sabha. It does go to the Rajya Sabha after being passed by the Lok Sabha, but the Rajya Sabha can only comment on it, make observations and make suggestions for the Lok Sabha. The Rajya Sabha cannot amend a money bill. So the suspicion, and I would say it is a suspicion, because there is no proof of it, was that it was included in a money bill because the government at that time did not have a majority in the Rajya Sabha. So it was passed as a money bill, whereas it had nothing to do with government revenues. In this case, an individual or a company would buy an electoral bond from the State Bank of India, which is an autonomous independent bank under the government, of course. And the person will give this bond to a political party who will then deposit it in its account. Therefore, government revenues are nowhere attracted or related to this process. So one of the reasons why we felt it was unconstitutional was that it was passed as a money bill, whereas it did not satisfy the conditions for a money bill that the Constitution laid down. Anyway, be that as it may, the scheme was notified in January 2018, and that is when the details became available, which were fairly startling. 4 laws were amended. The first was the Representation of People Act. The second was the Reserve Bank of India Act. The third was the Companies Act. And the fourth was the Income Tax Act. Let me describe the amendments made in brief, which will give us an idea of the purpose of these amendments. The Representation of People Act 1951 was amended by way of amending Section 23C, which said that a company as a political party which receives donations of more than rupees 20,000 each will have to inform the Election Commission of all these donations of more than 20,000 rupees each. The amendment to the Section 29C said that the money received through electoral bonds will not have to be declared to the Election Commission of India under Section 29C. So that provided an additional layer of opacity. And please remember, these were bonds. This was the scheme which was supposed to introduce opacity. whereas earlier any donation of more than 20,000 rupees would have to be reported to the Election Commission. But electoral bond donations, whether they were in crores, they need not have been reported. That is Amendment 1. Amendment 2 was to the Reserve Bank of India, where the Reserve Bank of India is supposed to be the only constitutional body to issue currency notes, and it has the authority to issue currency notes, promissory notes, anything which can be used as a means of money transfer without any record. That section of the RBI Act was amended, and it was said that the State Bank of India will be authorized to issue these financial instruments called electoral bonds, which can be used as bills of exchange without any record, and therefore an amendment in the RBI Act was required. The third was the Companies Act, which was extremely interesting. The Companies Act has a section which said that only a company other than a public sector company which has made profits over the last 3 years can donate to political parties. And the donation cannot exceed 7.5% of the average profits of the last 3 years. And the company was required to disclose in its books of accounts, etc., the name of the political party and the amount of money donated. Now, as a result of the amendment was that this limit of 7.5% was completely removed. This meant that a company donating to a political party need not have made any profits at all, but it could still donate. And therefore, it could donate any amount. It could be a loss-making company, but it could donate even more than its share capital and issued capital, etc., which came out to be true in the subsequent data. But anyway, let me not get there right now. The second was that the requirement for disclosing the name of the company and the amount paid to the name of the political party and the amount paid to the political party, the requirement for disclosing these was also removed. So now any registered company in the country, whether making profits or not, could donate any amount of money to any political party and nobody would know. The fourth amendment was to the Income Tax Act, which was again very ingenious. The Income Tax Act has a section called Section 13A, which says that the income of political parties is 100% exempt from income tax. So in that, electoral bonds were also added, as they will be treated as 100% exempt from income tax. There was another amendment which had earlier been made to the Foreign Currency Regulation Act, FCRA. That has a long history, but I will not go into that. I'll only just say briefly that there were two amendments made to the FCRA. The first was to the FCRA 1976, and second was to the FCRA 2010. They were made because in a petition by ADR in the Delhi High Court, the Delhi High Court had found that Congress and BJP both had violated the Foreign Currency Regulation Act, FCRA, and the High Court had directed that appropriate action under the FCRA should be taken against these two political parties. To save the political parties from that action, first the FCRA 1976 was amended. When the act of this FCRA 1976 had ceased to exist, the FCRA was amended by the then UPA government in 2010, and not amended, and it was reenacted in the form of what was called FCRA 2010. And the last section of FCRA 2010 said that FCRA 1976 is hereby repealed. So FCRA 1976 did not exist. In legal terms, it was non-est. But our parliament, to save BJP and Congress from prosecution, chose to amend an act which had been dead for 8 years. I had said at that time that it is like conducting knee replacement surgery on a person who has been dead for 8 years. But again, the matter stands in the court and nothing has happened so far. So these were the amendments to various laws that happened. Then, after the notification of the scheme started operating. State Bank of India started selling the bonds at the appropriate designated times and so on and so forth. And as that was happening, some people, namely Commodore Lokesh Batra, Anjali Bharadwaj, Venkatesh Nayak, etc., these RTI activists started seeking information from the government on how the scheme was actually formulated. And a journalist called Nitin Sethi wrote a series of articles in what was that called the Huffington Post, revealing all this. So very interesting things were revealed. And since this is a group of civil servants, or predominantly civil servants, it will be interesting for them to know that file notings showed that the Election Commission of India and the Reserve Bank of India had very strongly objected to the scheme. And their objections were in the form of that it may lead to conversion of black money into white, it could lead to formation of shell companies, and it could lead to foreign money being brought in through these shell companies into Indian politics and so on. These things were actually written in the letters written by the State Bank of India and the Election Commission. No, letters written by the Reserve Bank of India and the State Bank and the Election Commission of India, both constitutional bodies. They are not statutory bodies, which means that they are not been set by a law made by Parliament, but they are part of the Constitution. So constitutional bodies have a much higher level of respect and trust and power. But the views of both these constitutional bodies were overlooked, as is available in the file notings made by the then Finance Secretary of the Government of India, where he has said that the Reserve Bank of India governor was invited for a discussion and the scheme was explained to him, and he was quite satisfied. And the Election Commission had also been persuaded to accept the scheme, etc. Which, whether those recordings are true or not, it is impossible to prove one way or the other. But the fact is that subsequently the governor of the Reserve Bank of India did resign. One of the things that came out soon after these bonds were started to be issued, it was indicated in the scheme that the scheme will be totally anonymous and electoral bonds will not be identifiable in any way, shape, or form by anybody. They will have no name on it, no nothing, and it'll be just like unidentifiable instrument. But a journalist who was then working with this digital media outfit called the Quint, by the name Poonam Agarwal, she bought 2 electoral bonds of rupees 1,000 each. Probably the only bonds worth 1,000 rupees each that were bought, because all others were 10 crores and lakhs and so on and so forth. She took these 2 electoral bonds of 1,000 rupees each and got them forensically examined. And at that time, it was discovered that each bond had a unique alphanumeric code of some digits and some numbers embedded in the bond or in the paper of the bond, if I may say so, which was not visible to the naked eye, but was visible under ultraviolet light. So the statement that it was completely untraceable and anonymous, etc., proved to be wrong. Interestingly, this is the alphanumeric code is the feature which the gentleman who was then Secretary of Finance in a YouTube or a video discussion with me said that this was a non-existent feature. It was a feature which was embedded in the bond, but which did not exist. So I sort of was very confused that how can something which is embedded in a piece of paper, how can it be called non-existent? But he stuck to his ground, and that's what he chose to say. While the scheme was working right in the very beginning, even before it was introduced, before it was notified, it had been said in the scheme that the State Bank of India, who will sell these bonds, will keep KYC particulars of all the buyers. And we all know what KYC particulars are. And the scheme said that the State Bank of India will not reveal this information of the KYC to anybody unless there was an order from the court in a case and so on. So the question arose that if the State Bank of India are not going to share it with anybody, why was it keeping that information? Looking at that fact, it was speculated or it was apprehended that the information of a bond being purchased will be available to the government of the day, and more than that, to the party which is in power on that day, because State Bank of India would find it very hard, almost impossible, to not share this information with the Ministry of Finance if the Ministry of Finance asked for it. And once it was known to the Ministry of Finance, it will then known to the Minister of Finance, and therefore to the party of the Minister of Finance. So I had said at that time, and I have said it many times since then, that for those of you who are familiar with the layout of New Delhi, that somebody would buy an electoral bond, let us say, of 100 crores and start driving through a road called Akbar Road, which has the offices of the Congress party. And on the next traffic circle, this person would get a phone call and saying, "Hello, sir, how are you? I believe you have bought electoral bond worth 100 crores. So what is your plan?" And I used to lightheartedly say that only on hearing this, the person will turn his or her car around and take it to either Ashoka Road or to the Deen Dayal Upadhyay Marg, where BJP's offices are. So this was a light-hearted way of of saying that this scheme, by virtue of this access to information or differential access to information, will give the party in power an opportunity to choke the funding to all opposition parties. Now, this was an apprehension which was expressed in 2017, but subsequently, when the data for the first financial year of the electoral bonds being sold became known, it came to light that I think electoral bonds worth 212 crores were purchased that year, and out of which 200 went to the BJP, and 10 went to the Congress, or 200 crores went to BJP, 10 crores went to the Congress, and the remaining 2 crores went to the Prime Minister Relief Fund, because bonds which are not encashed are supposed to be deposited in the Prime Minister Relief Fund. So the first year's hard data proved that the apprehension that the scheme had the potential to choke the funding to political parties was indeed true. And subsequently, the data of subsequent years also came out to be the same. This was accompanied by several other instances where the government violated the scheme as it itself had formulated. The scheme had said that this is meant for Lok Sabha elections, and there will be a window opened for purchase or sale of electoral bonds every 4 years for 10 days. And in the election year, it may be opened for an extra 1 month or something like that. But soon after the scheme started, the Karnataka elections came by, and the State Bank of India was asked to, or the Finance Ministry was asked to request or to ask the State Bank of India to sell electoral bonds for another window. The Finance Ministry is reported to have written to the Prime Minister's office that this was against the stipulations of the scheme. But the Finance Ministry was told that this should be done as a one-time exception for the Karnataka state elections. It was done, and subsequently it has been done for every state assembly election. So the provisions of the scheme formulated by the government itself have been violated by the government itself. So all this was going on. In the meanwhile, we filed the case that we had filed in September 2017, continued in the court. There were two kind of perfunctory hearings, one in 2019 and one in, I think, 2022, where nothing significant really happened. And we kept filing applications for urgent hearing, because before every state assembly election, we would file an application for urgent hearing that the scheme should be at least stayed till the final decision is made, but the court decided not to do that. Then on February 15, as has been said, 2024, the Constitution bench, a 5-judge Constitution bench, gave a unanimous decision that the scheme is unconstitutional. And by the way, it only acted on the information or on the part of the petition which gave these legal reasons for it being unconstitutional. It has not yet adjudicated on the money bill provision, because the money bill part of this petition has been attached with 4 other petitions where there are violations of the money bill, and that is yet to be heard by a larger bench of 7 judges. So it is not impossible that even on the money bill argument, the scheme may be declared unconstitutional yet again. But that, of course, is in the future, and that is more of academic interest now. Now, the judgment came on February 15, and it said that the State Bank of India should give all information to the Election Commission of India within a certain amount of time, and the Election Commission should put it on the website for the information of the public. Now, when the judgment came, I mean, everybody thought that this is now kind of a done deal, so to say. But what was in store and what happened subsequently apparently was far more revealing than what all the data has revealed. I think 2 days before or 3 days before the due date, the State Bank of India filed an application in the Supreme Court saying that it needed 3.5 months to provide this data to the Election Commission. And the date they had given was 30th of June. Whereas people thought that since the data is available and should be available digitally, the State Bank, they should be able to give it, pretty much instantaneously. But the State Bank said it will take 3.5 months till the 30th of June to give this data, and they sought an extension of time from the State Bank. This was very surprising to I think, to everybody who was interested in this issue and following it. And I think the date was 4th of March. No, 4th of March. Yes, 4th of March, that they filed the application. They were supposed to give this information to the State Bank, to the Election Commission by the 6th of March. So on the 7th, they had not given it till the 7th of March. And on 7th of March, an application for contempt of court against the State Bank of India was filed. And a hearing was heard, I think, on the 8th or the 10th. I forget the dates. In that hearing, the State Bank argued that the data needs to be decoded, and it was held in 2 separate silos, one for the buyers and one for the sellers. And that process is very tedious and it will take a long time. However, after the hearing, the Supreme Court did not accept the State Bank's submissions and ordered that the data should be made available within 24 hours. Now, it was a great surprise that the data which the State Bank had said under oath in the court that will take 3.5 months, it was provided within 24 hours. Now, it has been claimed by some people, and I guess all of us have to assess it for ourselves, that saying that something will take 3.5 months on oath, which was actually done in 24 hours, was a case of perjury, of lying to the Supreme Court under oath. This was one issue that came up. Anyway, once the data was given to the Election Commission put it out on its website, and people started trying to look at that data and analyze that data. It was then discovered that while the information had been given in so-called two sets, the non-existent feature of the alphanumeric code was not disclosed. So people applied to the court again saying that the information has been given, but this vital information, which is the key link between the buyer and the seller, has not been disclosed. It was in the hearing of this application that the Supreme Court came down very heavily on the State Bank and even sort of threatened, I should say, the State Bank with action for willful disobedience of the order of the court, and asked the State Bank of India to provide all information it had in its possession about electoral bonds. And it asked the chairman of the State Bank of India to personally file an affidavit saying that they have supplied all possible information and no other information is available with them. So it was under these conditions that the alphanumeric codes were revealed. And what has been revealed is, I think, everybody in the audience is aware of the amount of money that has exchanged hands between various corporate houses, some known and some completely unknown. Companies giving hundreds of crores of donations via corporate bonds where they have made no profit. Companies making, I think there is some company which made donation of 140 crores and got a contract worth 14,000 crores. So there are similar multiple examples. I don't plan to quote them because they are all available in the media. I think what the behavior of the State Bank of India after the judgment seemed very unusual, to say the least, and bizarre, to say the most. It was very surprising the way State Bank of India behaved, and that remains a matter of concern. The other thing that the data that has come to light so far and that has been analyzed by several agencies, including various newspapers and so on, proves without any doubt whatsoever that there is a corporate political nexus. There is a nexus between political establishment of the country and the corporate sector of the country. And they are together in deciding how to run politics, how to run the government, etc., etc. As a matter of fact, this is not something which is a great discovery. It has always been known. But now it seems to have been proved beyond, by reasonable doubt, I would say beyond any doubt. As a matter of fact, Mr. Subhash Garg, who was the finance secretary in the government at that time, the scheme was being formulated. In an interview, another TV interview where I was present, he also said that the users insisted on anonymity of the donor as a precondition for using the scheme. which seems to indicate that the scheme was being formulated in consultation with the corporate sector. And if the corporate sector, and this is an if, it is not obviously a definite situation, if the corporate sector lays down a condition for using the scheme and the government decides to meet that condition to formulate the scheme, it is not in doubt who is calling the shots here. So this the whole process has revealed such things, and the revelations continue as the analysis will continue. Now the question is, what next? What next can be looked at in two ways. One is what next after this judgment and the revelation of the data. First of all, I understand a petition in the Supreme Court has been filed asking for a special investigation team, SIT, to be formed of independent people who will investigate the whole thing and who will sort of go into details of how much money has been changed hands and why and under what conditions, and then suggest suitable action. This is I suppose it's a very good idea. But my concern is that to find people who are independent of the government and of the influence of the corporate sector, who will look at it with dispassionately, with very, very objectively, I think it is going to be very difficult to find. And therefore, what the Supreme Court will do, I do not know. But that is one action which has apparently been initiated. There has also been some talk among some people about asking the political parties to return this money, which was because it was obtained through a scheme which turned out to be unconstitutional, therefore illegal, and therefore this money is illegally gotten. And apparently there are legal precedences that illegally gotten wealth cannot, the receiver of illegal wealth cannot be allowed to enjoy that illegal wealth. And the proposal that some people are talking about is that they should be required to, the political parties be required to return this money, and the money be donated to the Prime Minister's Relief Fund. The third is, which I mentioned earlier, is of perjury against the State Bank of India, because it seems, on the face of it, it seems that they had said something untrue under a sworn affidavit. Now, this is one set of what next. The other what next, which has been, I guess, which is in some ways included in the formation, the petition to form a SIT, is to have a complete analysis of the data that has come out and then see if there are any objectionable payments involved, and then take the matters to their logical conclusion, perhaps to prosecution also. Then the third, which is the biggest what next, is there has been a lot of talk in several circles that now that the electoral bonds have gone, we are going to be thrown into a morass of cash and black money. And therefore, Indian democracy is going to be drowned in cash and in black money. This is not untrue. But what we need to keep in mind is that I actually wrote a piece somewhere that there was life before electoral bonds and there will be life after electoral bonds. Electoral bonds came on the horizon in only 2017, and Indian democracy has existed from 1950 to 2016. And by all accounts that one heard and read about in the reputation of Indian democracy all over the world, everybody felt Indian democracy was doing reasonably well. It was not the perfect democracy, and it can be argued that there can be no perfect democracy. So Indian democracy has been doing really well, or reasonably well, let us say, even without electoral bonds. So electoral bonds came in, and they, in my opinion, added an extra layer of complexity and opacity to to political financing. And now that the electoral bonds have gone, we are back to where we were. But that doesn't mean that we are back to a complete mess. We are back to a situation where where corporates still have various, at least 3 ways of contributing to political parties, including a scheme called electoral trusts, which has been around since 2013, which was not very popular because in that scheme, the names of the donors get revealed, and therefore it was not popular. So we will be back to 2016, and the organization I work with, Association for Democratic Reforms, has been working since 1999 to try and improve the system. And we were working to improve the system even before 2016. And we will continue to do that, and many other people will continue to do that. The final answer to the question is, how do political parties, how do they get their money, and how should they get their money? The answer to that question, in my mind, is simple, and though some people may also think it is simplistic, is if we go back to the day when demonetization was done in the country, it was said that the country is now moving towards the digital age, and all payments should be done digitally. No less than a person than the Prime Minister exhorted us to make all payments digitally. And there was, if I recall, there was a full page ad in some papers on the front page about Paytm. Paytm, of course, is now in a bit of a disrepute, but there are many other UPI apps, United, I think it's called United Payments Interfaces. And we are supposed to be the world leader in that field. So if all citizens can pay even up to 10 rupees and 20 rupees through digital means, I am unable to appreciate why political parties should have a possibility of receiving up to 2,000 rupees in cash. So my recommendation is that all payments to and from political parties should be done using digital means. Anybody and everybody should be allowed to contribute to political parties, but everything should happen through digital means, which means that they will be transparent. So long as we have transparent collection and expenditure of money by political parties, I think it will ameliorate a lot of our problems, because political parties claim that they work for public good, they work in the public sphere, and they provide public service. So if they do all this, and there is a judgment or there is a direction or a decision by a full 3-member bench of the Central Information Commission, declaring that 6 national political parties are public authorities under the RTI Act. Of course, political parties have failed to follow these directions of the Central Information Commission, and the matter is in the Supreme Court. It is waiting to be heard. So the answer to how should political funding be done is that it should be done digitally and transparently. I think I will stop here, and then we will now take questions as we go along. Thank you very much.
Thank you, Professor Choka, for that enlightening talk. So I think many of the questions would revolve.
Sorry, you should switch on your video.
Many of the Thank you, Professor Choka. So many of the questions, I think, naturally would revolve around, what's the best way forward, right? I mean, in terms of articulating and moving towards a new system. So one of the questions that has come up from the viewers is that, is state funding of elections feasible and practical? And you have written on this. I have read articles in which you have mentioned about state funding. And I think you were critical of the idea of critical of the idea, not in its entirety, but you wanted certain other things to be taken care of before state funding of elections plan is put in place. Would you please elaborate on that?
Yes, I would love to, because it is raised very often. The first observation I have is that the expression state funding is kind of misleading. The question I ask is, where does state gets its money from? And the answer is very simple. The state gets its money from taxes that people pay. So, perhaps a more accurate method of describing this would be not call it state funding, but call it public funding of elections. The reason why I insist on this is not that it is a semantic or a question of using a different set of words. In India, unfortunately, I would say, we have a situation where people, all of us at large, seem to think that anything which the government does is free. In a Jan Sunwai, the members of a political party had said that our leader has given us the slogan, "Jo zameen sarkari hai, wo zameen hamari hai." People are, and the land which is owned by the government is owned by us. And government offers free electricity, and we are very happy. It offers free water, we are very happy. But we don't know that the water and electricity still cost money, and somebody has to pay for it. So when the government is paying for it, government has no money of its own. It has the money that the government has is from what it collects from the people. So my expectation and hope is that when people hear the word public funding of elections, they will think that it is their money which is being given for fighting elections. Whereas when we say state funding of elections, they feel that it is the government money, who cares where it is coming from. So the first observation is that it should be called public funding of elections, not state funding of elections. The second observation, I am not against public funding of elections per se. Philosophically and theoretically, it is a very sound thing. But there are two practical problems. One is that if we do decide that there will be public funding of elections, which in simpler terms mean that the government will give public money to political parties and perhaps to candidates for fighting elections. So my first question is, will it also imply that political parties and candidates in elections cannot take money from any other source? My own apprehension or hunch is that they will not agree to this condition. And even if they ostensibly agree, it will be impossible to implement this condition. And if political parties and candidates can take money from other sources, also in addition to public money, then I am against this. Because this amounts to what is called throwing good money after bad money. And in a lighter vein, since a lot of people in the audience are supposedly civil servants or former civil servants, we know the phenomenon of bribing. And there are certain departments in the government who are more notorious for taking bribes than the others. So if we take a department or a person in a department which is known for taking bribes, and we tell this person that I will increase your salary to 3 times your current salary, you please stop accepting bribes. Is that likely to happen? I mean, it may be called a cynical view of human nature, but I think it is not likely to happen. So therefore, so long as political parties and candidates so long as it cannot be ensured that they will not take money from any other source, I think public funding is going to be a waste. The second problem I have is that, let us say we agree to political funding, and then we decide, or we have to decide, how much money should we keep for this purpose, or in other words, to make a budget for public funding. So in the normal case, as far as I have seen in my long working life, is that we make budgets based on what happened in the previous year. And we provide for, a 10%, 15%, 25% increase for whatever reason. Now, there following that, we will have to know how much money was spent in the last election, so that we can budget accordingly. So for the 2019 election, there is only one estimate available, which was done by the Center for Media Studies, CMS. And they said that the 2019 Lok Sabha election cost about 55 to 60,000 crores of rupees. If you read the report of the Center for Media Studies, they list out something like 35 to 40 activities, which they say have not been included in this estimate. So which means that the estimate is a conservative or an underestimate. Be that as it may, even if it is 60,000 or 80,000 crores, the point is, unless we know exactly how much was spent, we cannot budget for it appropriately. It cannot be an unending stream of money. So budgeting will be possible only when political parties share with people at large or with the powers that be how much money they have actually spent. And I doubt whether they will ever do that. So given these two conditions, I think public funding of elections is not possible. The other thing I would like to point out is that the report which is most often quoted in support of public funding is what is called the Indrajit Gupta Committee report of the Parliament. Now, if you read the first paragraph of the conclusions chapter of that report itself says that it uses the expression state funding, that state funding of elections can only be possible if it is preceded by several other reforms, which include democratization of the internal functioning of political parties and transparency of political parties. So, Indrajit Gupta Committee report, which had very eminent members, recognized the fact that state funding or public funding will only be useful if political parties' functioning is reformed and made democratic and transparent. Without doing this, state funding will not serve its purpose. This is what the Indrajit Gupta Committee report says. So, forgetting all the other perquisites or prerequisites and then saying, let us do state funding is, in my opinion, putting the cart before the horse.
Yeah, absolutely. And I think it was ADR, which again, was one of the organizations that was part of the, initiative to make the declaration of, whatever funds that the political parties get, right? I mean, as a measure towards transparency. And the Law Commission has also mentioned the same thing that you are talking about in terms of that other factors or other elements like internal democracy within parties. So certain aspects of this transparency in terms of political parties declaring their, annual receipt of funds, so on, has been put in place. Do you think, as a corollary to this, what you said just now, can certain aspects related to internal democracy and organization of the parties, can that be brought about by judicial intervention and activism leading to judicial intervention, or is it something that can only come from within the parties themselves?
You see, the Law Commission of India, which you mentioned, in their 170th report, which was submitted in May of 1999, said that the political parties they form the government, they run the government, they make all decisions, and it is completely unacceptable that in a democracy, institution that form the government and run the government should be non-democratic. And it went on to say that political parties should be made internally democratic and financially transparent by law. And I am quoting this word by law from the Law Commission's report. Now, the catch 22 is, who will make this law? The laws are to be made by the parliament. The parliament has people who are first chosen by political parties and then chosen by the people. By the way, this also is an important issue. That if I may be allowed a little digression,
Please.
Everybody, I have asked this question from a lot of people, the question being, where does government come from? Everybody says we elect the government. And I have asked this question from thousands of people or tens of thousands of people across the country, rich people, poor people, educated people, uneducated people, young people, old people, senior bureaucrats, big business persons. Everybody says we elect the government. So when I first started asking this several years ago, I was very happy that the concept of democracy has seeped in so deeply in the Indian psyche that everybody believes we elect the government, so we cannot go wrong. Then I kept wondering, then why are we going wrong? Then it occurred to me that when I started asking people that when you go to a polling booth and you press a button on a machine, are you voting for who should be the government or who should form the government? First, there is sort of hoo-ha, but then people realize and agree that they are voting for one individual. And with that individual is called a candidate. So the next question was, where do candidates come from? And here is the key answer, that the candidates come from are those people who are chosen by political parties. And my first statement, without spending too much time on it, my first statement is a voter's choice is pre-constrained by the choices made by a set of political parties. I will repeat, a voter's choice is pre-constrained by the choices made by a set of political parties. Then we vote, we vote for whoever we are told to vote for, or out of a list of 8, 10, 15. So we choose somebody and the person gets into the parliament or the state assembly. So the question there is, does a so-called elected representative have a choice of which bill to support and which bill to oppose? The answer to this question is no, because of the anti-defection law. So if we look at these two statements, statement one, a voter's choice is pre-constrained by the choices made by a set of political parties. Statement two, a so-called elected representative's choice is completely controlled by the political party. If we read them together, what do we get? We get that the government comes from political parties. And it is those political parties which the Election Commission said must be made democratic, internally democratic and financially transparent by law. Now, to continue that earlier story, if the parties form the government, we have a vibrant democracy on the top, but the pillars who form the government are non-democratic. This situation is completely unsustainable. You cannot have a democracy on the top supported by undemocratic institutions. This is what the Law Commission has said. So the law, it is going to be very difficult for the parliament to make this law because they don't want to make this law. It can only be done by a joint effort by the citizenry, the media, and the judiciary. These three institutions have to come together. Only then can political parties be, urged or coerced or forced to make such a law. But this law is essential, and this is the Law Commission actually quotes the German constitution, the post-war German constitution, when after the, whatever happened in Germany happened, the German society decided that they will make a new constitution in which there is a specific chapter on the functioning of political parties. And the Law Commission of India in the report has also given a draft of a chapter like that. But ADR also got a committee headed by Justice M.N. Venkatachalaya to draw up a draft of a bill to regulate the functioning of political parties, which has been around for about 10 years. We have taken it to all political parties, but nobody is interested in it. So unless political parties are made, I only add the word demonstrably internally democratic.
Yeah.
Because even today, a lot of parties says we are democratic, but none of them is. So they should be demonstrably internally democratic, and they should be financially transparent. Only then can this happen.
One of the questions that the viewers has asked is, can the importance of money power ever be reduced in politics? What are the best practices with regard to this from across the world that you can cite?
There is only one way: transparency. You cannot devise a system where money can change hands confidentially and the system can work objectively. So to me, the only answer is transparency. In terms of best practices in many of the so-called mature democracies, there are rules about transparency, and the rules are enforced. Money is something which is needed, there's no question. And, in some countries, political parties run commercial institutions and so on. They make money-making activities, that they are allowed to do that. I don't know whether that should be appropriate or not. But my firm belief is that money should be transparently obtained by political parties and transparently spent. I have no doubt about, who should donate, who should not. Anybody should be allowed to do what they want, but it should be done transparently.
The ruling party and the government have argued, as you would have noticed, in the aftermath of the scheme being struck down, that there is nothing iniquitous in the system, in the sense that it's not just the ruling party at the center which has received bonds. Some other parties, like state governments, state ruling parties in states like the TMC and the DMK and so on, have received funds. So there is nothing iniquitous about the system. So this is referring to your point before that, political parties were being choked because, only the central government has access to the State Bank of India in terms of, knowing who the contributors of the bonds were. So how do you say that there was nothing iniquitous in the system?
You see, choking is not a either or 0-1 activity. You can also partially choke. And the data as is available, as far as I know, is that a little more than 50% has gone to the ruling party at the center. And therefore a little less than 50% has gone to all the other opposition parties put together. Now, if this is not iniquitous, I would like to know what is iniquitous. And when the Supreme Court of India says, Supreme Court of India has given two reasons for this decision. One is that it has disturbed the level playing field. This is a finding by the Supreme Court of India by a five-judge constitutional bench in a unanimous judgment. They say it has disturbed the level playing field. Now, if the ruling party still says there is no inequity, well, I can only say they are welcome to say what they like. But the The law of the land today says the level playing field was disturbed, which is another way of saying it is iniquitous. So, ruling party can say what it likes. The ruling party has also said that all these disclosures have become because there were electoral bonds. If there were no electoral bonds, we would have never known this. Which means that whatever the State Bank of India did after the judgment has been completely forgotten.
Yeah.
So this is, I mean, I don't want to go on and on about this, but this is the way political parties deal with such situations. I mean, it is like Ashwatthama is dead, and then softly, but he was an elephant.
Yeah. So I was looking at the Center for Media Studies research that you mentioned, right? I mean, and it was talking about like the last elections in 2019 cost about 60,000 crores, not just spent by the government, but political parties. And vote buying in many states was specifically mentioned in that, like one of the things to reform. So we cannot just focus on, a specific aspect of political financing. Ironically, looking at that report, what came across was that before electoral bonds, the gap between the ruling party and the main opposition party seemed to be less in terms of political expenditures and political financing. So, and that gap has become, humongous if you see the main opposition party and the ruling party. And this has come after the bonds system was introduced, ironically, because this was supposed to increase transparency. So, people who are supporting the party and the government would argue that that's because only reflecting the weakness or increasing weakness of the main opposition party. It has not got anything to do with the system itself, right? So you rightly mentioned the Supreme Court itself in its judgment noted about the level playing field. But I was struck by the fact that the Center for Media Studies research shows the gap was not as large, say in 2004, 1998, or even 2014 elections when the BJP got more funds than the Congress party in the elections in 2014.
So the fact that the gap has increased, I think, is evidence supporting the increased iniquitous situation.
Yeah.
That the gap has increased only shows that the situation is inequitable.
Yeah.
So there is, I mean, I see this as supportive evidence of what has been said by the court. It does not negate that.
Yeah, absolutely.
Yeah.
And one of the things that the people, the ordinary people and ordinary citizen, what they are confused about is the fact that people think that bonds, after the bonds was introduced, bonds are the only way to pay to a political party. That is not correct. Right? I think in one of your articles you mentioned that it is still only about 15% of the total political financing.
Well, I did not mention the former finance secretary said so.
Yeah. I think it was Mr. Garg.
Yes,
Mr.
yes.
Garg. Yeah.
And he should know.
Yeah. This is something that I like whoever I've talked to in conversations or as part of my research, nobody knows this. They believe that the earlier system was cash, and now what we have is after the bonds is only bond.
Yeah. No, you see, this is a very sad commentary on how informed we as the people or electorate are.
Yeah, that's true. Many of the things.
It is a sad commentary on our lack of information or whatever, and it is also a sad commentary on the media.
Absolutely.
I mean, it is the media's job to spread information of that kind. But you know how the situation is.
Yeah. Regarding your point about all payments done digitally through digital means, and which would obviously bring about transparency, complete political transparency in terms of who is contributing and who is receiving it. But the corporations and businesses argue, or they argued before, that transparency will lead to, say, targeting by other political parties and state governments. So I
Yeah.
think, do you think there is a merit in that kind of argument? Because
No. I don't think there is merit, because let me, we often don't ask basic questions. Now, if there is victimization of donor to a party by the ruling party, now who does this victimization? The perpetrator of the victimization is a political party, whether it is in power or it is in the opposition. So the act of perpetrating whatever, not discrimination, I'm missing the word, making life of a donor difficult who donates to an opposition party is done by the ruling party. And the opposition party in the center may be the ruling party in the state. And that in the state, the same party will do the same to the ruling party's donor. Now, this is a situation which is created by political parties. I mean, victimization is done by political parties. Now, political parties insist that they will not stop doing this, but they still need money. And therefore, when the society comes up with a solution to this problem which political parties have created, which is transparency, political parties say, no, this solution is not acceptable. Solution should be such which does not hinder our wrong activity. We will continue to do wrong, but we cannot stop doing that, but society should take care of the problem. Bhaiya, you are creating the problem yourself.
Yeah.
How do you expect the society to solve it? This is why I actually maintain that our political parties, all of them, have been very irresponsible in several matters of public interest, country's interest. I can give you chapter and verse. There are many instances where political parties as a group have been irresponsible. And they do not tolerate anybody saying so. But that is the fact. This is the same about people with criminal cases pending against them getting tickets.
Yeah.
They say, we will keep giving it. The society should deal with it. You can't do that.
Absolutely. And as ADR data shows, like the number of candidates with criminal cases has just skyrocketed since, every election it is going up by almost double.
You see, all examples that I give are from ADR data.
Yeah.
I have no other source. So these are all examples from real experience. And they show, when we look at it as a pattern or in totality, that irresponsible behavior by all political parties put together is causing very serious damage to the democratic fabric of the country. And there is a very urgent need to reform the functioning of political parties. They cannot be above the law.
Absolutely. One of the questions that has just come up is our finance minister said that the government will bring the electoral bonds again after coming to power. The viewer wants to know, is this statement within legal lines under legal, is it a legal statement?
Well, I am a lawyer, but I don't know whether it is legal or not. It is an opinion. And the finance minister also said that we will bring it back with wider consultations with stakeholders.
Yeah.
And I have written about this, that this fact that she has said wider consultations means that earlier they did not do wider consultations. Earlier they consulted only the corporate sector. They did not even heed the advice or opinion of constitutional authorities such as the Reserve Bank of India and the Election Commission of India. So if they bring a scheme with wider consultation, and the scheme does not suffer from the infirmities that this scheme suffered from, and the scheme is not unconstitutional by way of being brought as a money bill when it has nothing to do with the money bill requirements, then there's nothing wrong in it. But to say that, I mean, if the statement is meant to be that Supreme Court can say what it's like, we will do what we like, and then Supreme Court would strike it down again, I suppose, or I hope, if it is the same scheme. But, commenting on statements by politicians is not an easy job and not a very worthwhile job.
Yeah, especially in the election season. So
yes.
Yeah. So regarding the data, I think you were mentioning about the fact that the limits for contribution were removed, right? I mean, the 7.5%.
Yes.
Limit to profit-making companies. But recently, the Hindu had put out data showing that 45 loss-making companies had, contributed nearly 1,500 crores, and of which 75% went to the ruling party. I think that was demonstrated. Your point was illustrated by that specific data that had come across. The Hindu had published it with the names of each company, and all of them were under losses of various, amounts, and it's a very interesting statistic. One viewer wanted to know, will there be ever an investigation of quid pro quo payments and securing of contracts by businesses, after payment of bonds? I'm sure you heard about this incident of Aurobindo Pharma, I think, which contributed, bonds, and then, the person secured bail after arrest. And, I think that was the most prominent case of that kind which came across. I'm sure there are others of this kind. Do you think there would be, because again, as you say, it is a political party in power, or the state government, a party in a state government running a state government who has to do the investigation. So will that ever happen? Or is it again citizenry and public activism that can lead to this?
Well, to a certain extent, I mentioned that some people have, I think, filed a petition in the Supreme Court asking for a special investigation team, SIT, to be formed.
Yeah.
If that SIT does get formed, then I suppose something may come out of it. But it is going to be very difficult, as I said, and the data is so large and so much information is available that it is going to be, I think, more or less impossible, if not extremely difficult, for anybody or any entity to do a complete investigation. So I think interested people will have to keep working on it, whether it is citizenry or civil society groups or media investigative media. And there are all kinds of people working on it, and I think it will go on for quite a while. It's not going to die out in a hurry.
Yeah. And I think it goes back to the point that you mentioned before, right? I mean, if the media or the mainstream big media had, done its duty, it would have, all this big data needs a lot of resources to, parse and.
Yes, absolutely.
No individual or even small organizations can do this without, adequate resources, because this is huge data we are talking about. It's not easy.
Yes.
So I think we have spent quite a bit of time in the discussion. I want to ask you a couple of last questions regarding, what is the lesson that you have learned from your long years of activism, almost 20 years, more than 20 years now. So
20,
I don't want
25.
Yeah, 25. I think it's from 98, right? When ADR was set up.
99.
Yeah. So I don't want to leave the viewers with kind of a depressing and pessimistic outlook towards our democracy. And I think you have learned a lot from these 25 years of activism. And we can definitely say that this is indeed one of the landmark judgments of independent India. So I think you can take a lot of pride in what this has led to, right? So drawing upon this kind of activism, what is the kind of lesson that you will leave for the viewers in terms of the future generations and the young viewers who want to do something to change democracy?
Well, first of all, let me add that it is not my doing. There are many people involved in it. There are many people in the organization that I worked with, ADR. But there are also many people outside ADR who have contributed. As I said, transparency activists like Commodore Batra, Anjali Bhardwaj, Venkatesh Nayak, journalist Nitin Sethi, Poonam Agarwal, and a host of other people who have actively worked in it. So if it is an achievement, it is an achievement of a large number of people. I am just one of those, a small part of that large group. And any such significant effort cannot happen, cannot be done by one individual or a few individuals. It needs a large group. And it takes time. I think what I have learned is that, first of all, you said young people who want to change democracy. I want to qualify that. I want young people to improve democracy, not change democracy. Change is a multi-meaning word, but we need the democracy to be made more effective and more widespread and deeper. The only lesson I think I can draw for myself is that it is not an easy thing to do. It is very difficult. You said you want to leave the group with an optimistic, kind of hopeful scenario. I am afraid the scenario is not hopeful. Anything like this, it takes a lot of dogged effort. You have to be persistent. You have to, just be at it time and time again. These successes are very few, but they are the things that keep you going. And many of your efforts fail. And the reason why I've repeatedly been saying that all political parties have a problem is because in many of our efforts, all political parties have become unanimous. They may be at each other's throats for everything else, but when it comes to this kind of reforms, they all get together. And I don't blame them, because they are perhaps afraid of change. They are comfortable with the existing system, and they feel if the system were to change, they don't know what will happen to them. But I think in the interest of the nation, in the interest of democracy, in the interest of the people, such efforts have to be made, and they have to be made at a considerable cost, a lot of which is emotional cost. But that is part of the territory. No, there is no other way. There is no easy way. It is a difficult thing. I don't know how many of your viewers would understand an Urdu sher, which I can recite if you like. It just came to mind.
Yeah, of course. Yes.
This refers to a lover, and it describes the condition of a lover, and which can be extrapolated to the condition of a so-called activist, I suppose. And the sher says, आशिकों की शक्ल कुछ भूत सी होनी चाहिए. Ashik is a lover, that the appearance of a lover should be like a ghost.
Yeah.
आशिकों की शक्ल कुछ भूत सी होनी चाहिए, अक्ल उनकी नाप में 2 सूत होनी चाहिए. The brain or the mind of the lover should be very, very small. He should not have too much brain. आशिकों की शक्ल कुछ भूत सी होनी चाहिए, अक्ल उनकी नाप में 2 सूत होनी चाहिए। इश्क करने के लिए कलेजा ही काफी नहीं, खोपड़ी भी मजबूत होनी चाहिए। If you want to be a lover, you should not have a strong heart. You should also have a strong head, so that when you are beaten on the head, your head does not break. So you need a strong heart and a strong head, or the strong back, where you perhaps will be beaten up, metaphorically, of course. So there's a pain associated with it, which is inescapable. So it's hard work, it's frustrating work, but it can also be satisfying.
Yeah, absolutely. And, and there's, as you say, it is difficult, and, the path is not easy. But I myself rely on a lot of the data that, ADIA has generated, and it is really revealing to look at political parties, their operations, and so on. So it does a lot, in my view, to democracy, to, in terms of improving it, to have organizations like yours that has done this job. So thank you, Professor Chokar, for this enlightening talk, and also for taking all the questions. It has really been rewarding. I think I'm hopeful that everybody else is similarly satisfied with with our present session. Thank you so much for joining our organization to present this.
Thank you for giving me this opportunity. Thank you very much.
Thank you, sir.
Over to you, Mr. Babu.
Yeah, we are thankful to Professor Jagdeep Chokar for the illuminating talk, and also various illustrations that he has given from his activist perspective. Our thanks to Professor Nissim Manuthukaran for agreeing to moderate the session and then leading the talk in such a way that it is quite there is a free exchange of views, and also quite educative in the questioning. We are also thankful to both of them for facilitating the webinar, as we are in 3 time zones. Professor Nissim in Canada, Professor Chokar in US West Coast, and we in India. And also thankful to Professor Chokar especially for agreeing to talk to us at 6 a.m. in the morning from his house. I thank the audience for joining the webinar in spite of odd time and the IPL game going on. Our thanks to Sri Sadiq for his continued technical support. Our next webinar is on Russia-Ukrainian war on 26 May, and it will be addressed by the former Ambassador Venkatesh Verma. Thanks, one and all. Thank you. Yeah. Sadiq, it is disconnected?
Disconnected.